Good morning and welcome to the First District Court of Appeals. We have 3 cases set to be argued this morning. When I call your case, please rise, state your name, the party you represent, and your readiness to proceed. And I understand we do have one attorney appearing remotely. Please do not feel the need to stand up. You may remain seated. The first case today is C-24-0315, Loyalty 360 versus Empirical Edge. Are the attorneys present this morning?
Louis Schneider on behalf of the appellant.
Morning.
Good morning, William Katz on behalf of Appellee Empirical Edge, Inc.
Good morning. The second case is C-24-0295, Courtney versus Durrani. Are the attorneys present?
Yes, Your Honor, you're reversing for appellants in both cases. Alan Stavin and Ben Moran for the appellee in both cases.
All right, so you're both here for both cases. All right, thank you very much. And just for completeness, the second case is C-24-0296, Colblin versus Durrani. All right, we will proceed with the first argument, C-24-0315, Loyalty versus Empirical Edge. If counsel for appellant wants to come forward. Would you like to reserve time for rebuttal?
5 minutes, Your Honor.
All right, you may proceed when you're ready.
Good morning, Your Honors. May it please the court, Louis Schneider on behalf of Appellant Loyalty 360. This is a fairly straightforward appeal. The briefing was relatively brief and directly to one point, which is the trial court judge essentially weighed the evidence instead of construing the evidence in favor of my client when the trial court judge ruled on a Rule 50 motion for a directed verdict. She did not apply the correct standard. She basically chose to believe some witnesses, not believe other witnesses, discounted testimony that was presented, by my client through 2 witnesses at trial, and essentially ignored those witnesses' testimony when finding that my client did not prove its claim for breach of contract and also did not prove its claim for unjust enrichment.
Did the trial court find a contract to exist or not to exist?
No, the trial court's decision pretty much says that according to her interpretation of the witness's testimony, that the plaintiff, the appellant, my client, did not articulate what the terms of the contract were for whatever the judge considered to be her level of specificity for that.
So then what do we make of the language that follows, what I believe you to be talking about, that meeting of the minds language in the order? What do we make of the language that follows that says that Loyalty breached the contract by not paying first?
That's a perfect example of the trial court judge not applying things correctly. So you can't say out of one side of your mouth that there's no contract and then say out of the other side of your mouth that there was a preemptive breach by the plaintiff in the case or the appellant in the case. So there's either a contract or there's not a contract. If there's not a contract, my client didn't breach anything. But the trial judge specifically said that in this case there wasn't enough evidence to show what the terms of the contract were. But then the trial court goes on to say, oh no, the terms of the contract required payment in a certain amount of time, or prompt payment of invoices, even though there was no evidence of that presented to the trial court. That was from my clients. Then that is a direct example of the trial court not construing the evidence in my client's favor. This isn't a decision from the bench after both sides have presented. Instead, it's a Rule 50 motion.
Can I ask about that? So there's at least a 10th district case that has said that Rule 50 is not applicable to bench trials. And so was that the proper rule for the trial court to even look at in this case? Because the case I'm looking at discusses Civil Rule 41B2 rather than a Rule 50.
The judge made its decision under Rule 50. If the judge erred by ruling under Rule 50, then obviously that's another error by the trial court judge. We appealed the decision under Rule 50 based on what the trial court stated. But if this court is inclined to find that rule is not applicable and the trial court erred by that, then this
What do you think about the application of Rule 41B2 involuntary dismissal? Because that's a different standard.
It is a different standard, and if the trial court would articulate its reasonings for the Rule 41B2, that would be something that could be addressed on appeal. The trial court didn't do that here. The trial court instead said, I'm ruling under Rule 50, and here's what I have.
I've seen at least one case where an appellate court construed the motion for the directed verdict as a 41B involuntary dismissal. At least I believe it was the appellate court that did that. What's your position on that?
I've not asked this court to do so. I do not believe the appellee in its briefing asked this court to do so. Our briefing does not address that.
Could we sua sponte do that?
This court could obviously sua sponte do whatever it would like, whether or not it's legally appropriate or not. That's not an issue that I've actually reviewed or am prepared to address that today, Your Honor.
So your assignment of error is simply under Rule 50, and I mean, it's a correct statement of the law. The judge has to construe the facts in your favor. But if Rule 50 was inappropriate here and Rule 41 would have been more appropriate, the judge then is allowed to weigh the evidence, right?
Again, Your Honor, I'm not ready to address that, and that's
Okay.
not what happened here. I think the
Okay.
judge would need to articulate, the trial court judge would need to articulate that they're specifically doing that
Mm-hmm.
and saying, hey, you haven't proved it here. On that issue, my client has presented sufficient evidence that there was a contract. My
Right.
client paid actually $165,000 after this.
Well,
there was-
what were the terms of that contract? Can you point us to evidence explaining the terms?
Yeah, and it's laid out in my briefing, and I cut and pasted the sections of the trial court transcript of that. It was basically a fee-for-service contract. My client was a company that does marketing and hired a company that has developers based in India to provide website and app development services.
Right, let's say we agree with you that there was an agreement to perform technology services, $50 an hour.
Right.
Were there more terms than that, or was that it? Was it just a simple contract like that?
My client needed the developers to be certified in a development platform called Kentico, Kentico.
Right, we're familiar with that aspect.
Okay.
Was there a meeting of the minds as to that, what you perceive to be an essential term?
My clients would say absolutely yes, there were a meeting of the minds of that, because that's the reason that Empirical Edge got hired, was that they were supposed to be providing Kentico certified developers. My client later found out that a bunch of people that were working on this project were not Kentico certified developers, and that is why my client had.
Who testified, like, can you point us to the evidence in the trial as to who would have agreed on behalf of Empirical that we are going to provide Kentico certified employees?
Yeah, that was the owner. I believe his name was Mr. Patel. That basically, that there were Kentico people who were going to be provided, but he said that there's no such thing as a Kentico certified developer, and there was a dispute of fact on that. However, the trial court never got into that in its decision on that, and that's not something that obviously we can address, in the Court of Appeals, since the trial court basically glossed over that. And instead, basically, there wasn't even a meeting of the minds on the issue of whether or not there was an agreement as to Kentico certified developers.
I have a question that's very similar to hers,
Sure.
but just slightly different. Can you point me specifically to evidence showing that your client specifically told your enterprise that the employees must be Kentico certified?
Yeah, that Carly Stemmer, who was the vice president of operations, testified. And if you take a look at her trial testimony on pages 181 to 182, and then her trial transcript from 192 to 193, that there were supposed to be Kentico certified developers. Their entire website platform ran on Kentico.
What pages did you just say?
181 to 182, and then the trial transcript from 192 to 193. And that was Carly Stemmer. And she testified very clearly about, what was needed, and then also very clearly about the problems that Loyalty 360 had. She was very clear and concise in her testimony And for whatever reason, the trial court decided, to ignore
Well,
it.
wouldn't her testimony, I've read what you're talking about. And doesn't that really go to your assertion of breach when she's talking about the failures of the app and how it didn't sync with the website and how the registrants couldn't navigate the technology? I mean, that all speaks to your allegation of breach. Where is the testimony that explains how that was an essential term of the initial contract and how the parties had a meeting of the minds that they were agreeing that the functionality was an essential term?
Okay. So, and I've quoted it verbatim on page 5 of my brief, and she says, we were looking for someone to help develop our website, and with Kentico, the tricky part of it is the technology isn't as widespread as you would think. They do have U.S. clients, but it's not as widespread as some other technologies. So with that, we were introducing the team. We posted a job on Upwork. They connected with us, said, yes, we're certified with Kentico. So Carly Stimmer specifically said, we need a Kentico developer. And they connected with Empirical Edge, and Empirical Edge, according to Carly Stimmer, made the representation, hey, we're certified with Kentico. We can handle your needs as a website developer.
All right, and so you view that communication, that representation, that we know how to do this work, as a meeting of the minds and an essential term of their subsequent contract?
But yes, because of the type of agreement that it was. It's fee for services. It'd be like if you paid somebody to come over and, do a specialized painting on your house, and they said, yeah, I can definitely do that, mural painting on your house, and they come in and they've got no training, no certification, nothing for what they do. It's like hiring a lawyer and you say, hey, are you certified? You got your bar passage card? And he's like, oh yeah, no problem. And then you find out, hey, this guy doesn't have a bar card. This guy's not a lawyer. Sure, he acts like a lawyer and he talks like a lawyer and he can file things, but he's not certified to do that. So yes, there was no written agreement that, absolutely this person would have this level of Kentico certification. But that's not what was here. This was a fee for services contract. They said, are you Kentico certified? They said, yes. And they allowed them to do work on their website for several years, had lots of problems with it, and then found out these guys are not certified, and that's the reason why their website is not working, and that's the reason why they've paid all this money and they haven't gotten the benefit of the bargain.
So are we just focusing, I know the trial court just focused on the website, not the mobile app, because there was some discussion about the mobile app not working either. Is the website the only thing that we're really looking at here?
It's both, but primarily the
'Cause
website.
that was what was referred to in the complaint. Okay.
Yes, and I know there was some discussion about that, whether or not the mobile app was properly, before the court. There was testimony on it. However, that's not part of this decision. The decision that my client is appealing is that the wrong standard was applied. The facts were not construed in favor of my clients the way that they were supposed to, if this is what the judge is doing. And this court needs to reverse that decision because it was incorrect. As a matter of law, she did not do what she was supposed to do. And that in and of itself, obviously, is going to send it back down to the trial court, and if the trial court wants to issue an involuntary dismissal, the trial court can. If the trial court wants to allow the appellee to put on evidence and then issue a bench decision, entering judgment against my client, the trial court can, and I can appeal that decision under the proper standard. But this court's been asked to review the trial court's decision under Rule 50. And if the trial court applied the wrong standard and did not construe the evidence in my client's favor, either the breach of contract, and then if you get even down into the unjust enrichment claim, because the trial court found, hey, you don't have a contract here. You haven't proven what it is. The unjust enrichment claim fills that gap and says, my client paid $140,000 to get a website that didn't work and an app that didn't work. Where's my relief? And the trial court said, well, construing all the evidence in your favor, I still can't help you. No explanation, no discussion of that claim at all. No explanation as to what my client paid, what benefit my client received. There was no discussion of that by the trial court. And, Your Honors, I would respectfully request that this court reverse that decision and send it back down to the trial court. Thank you.
Thank you. Mr. Katz.
Good morning, Your Honors. May it please the court. I think Your Honors have clearly read the papers and the transcripts very thoroughly, so I will endeavor to be brief. First of all, the court did not find that there was no contract. They simply found that the contract did not contain a number of the terms that Loyalty 360 is claiming. So in effect, the court said, yes, there was of course a contract in the sense that my client provided services to Loyalty 360. The contract simply did not contain many of the terms which Loyalty 360 tried to cram in there without evidence. That's sort of in response to that first issue.
Well,
The
hold on,
Contigo
before
issue.
you go on,
My
excuse me.
client was called as an adverse witness during the plaintiff's case, and he offered extensive testimony on this Contigo issue and explained that.
Mr.
Contigo is
Katz,
not-
are you able to hear us? Are you able to hear us?
I can hear you now. I could not hear you if you spoke previously.
I did. I was going to ask you a question. After reading through the entry and reading through the transcript where the trial court granted the directed verdict, whether that was proper or not, the trial court, to me, seemed to find in the alternative that if there is a contract, then X. But it didn't seem like the trial court conclusively found that there was a contract.
I agree that that is what the written order says. Having been in the courtroom and having argued the motion, I think at least the argument that we made was that there was a contract and that we provided services on an hourly fee basis to update an existing website as opposed to building something new from scratch, and that the plaintiff attempted to read into that contract a number of terms that didn't exist. So whether it's that first step that judge says no contract whatsoever, or she made that second leap, which I believe she did when she said they were the first party to breach, and there was extensive testimony on that, by the way, where we went through the billing records, and it showed that from the outset of this engagement, the defendant was late on virtually every single payment. And their complaints only came months after my client said, you gotta pay me or I can't do any more work for you folks. They didn't even do that. It was when we said, you know what, we gave you a chance, we bent over backwards here, and you're still not paying us, we're not doing any more work. We're gonna in fact bring suit against you in New Jersey, which we did, that these complaints started arising as to the nature of the work, this notion of this Contigo issue, which again is not even a real issue. Contigo certification is something you pay a company for. It's not a programming language. And DePaul Parikh, my client's principal who testified, I believe opposing counsel heard him as Mr. Patel, he explained that all of his developers are in fact extremely competent, many have PhDs, in the underlying coding language and are therefore more than capable to coding Contigo, which is just a branding of another language which they are extremely well versed. So I hope I answered your question.
You did, thank you.
So I agree with your honors though that the proper standard that should have been applied here was 41B2. It appears to be an innocent error by the trial court to refer to Rule 50, which would obviously apply in a jury trial, not a bench trial. And judicial economy simply requires that this court sustain the trial court's decision and sua sponte rule under 41B2, and that it's quite clear where the trial court was going, and that to send this back down and have the trial court issue a new opinion saying, I've weighed the testimony of the parties and I've reached the same result, will not be doing anyone any favors. It's quite clear the court found that they were the first breaching party, that the contract does not have the terms they claim it does, and that they weren't unjustly enriched, and that they hired a company to provide hourly services to address an existing website which had issues. That's why my client was brought in to fix an already failing website. And when you come in to fix an old broken parts, caveat emptor type of situation. If you're fixing an old used car, you don't know what you're going to find when you get under the hood. That's why this was done on an hourly basis. And the fact that it took time and energy to do this is an unfortunate reality when you choose to try to fix the broken item rather than start from scratch. The reality here is Loyalty 360 did pay for what they agreed to pay. and after the fact, to avoid their obligation, started raising complaints which didn't exist. The trial court saw right through that and found against them, and for that reason, this court should sustain the decision of the trial court. Thank you very much.
Thank you. All right. Rebuttal?
So, Your Honors, there hasn't been even a motion or any briefing addressing the issue of Rule 41B2, either by the appellee or by this court for us to address that. However, even if this court construes it under Rule 41B2, the trial court still erred. So the trial court did not even understand that you can't say that there's not a contract, yet a party breached the contract. And then also, if the trial court found that there's not a contract, the trial court completely ignored my client's claim.
What about the argument that there was a contract, but that it didn't include the terms that Loyalty claims it did? Can you respond to that?
Yeah. The trial transcript lays out the terms. We will pay you money for services that you provide, and your developers are supposed to be Kentico certified. You didn't do it. My clients testified consistently and in depth about the problems that they had with their website. And if you're paying somebody $140,000 for website work, you just expect things like your website to work. It's not this type of thing where you're like, oh, I'm trying to invent the internet. $140,000 is a lot of money to a small business here in Hamilton County. And they, in good faith, made payments and didn't get the value for the money that they paid. This isn't the type of case where my client didn't pay anything at all or said, give us a $200,000 website and I'll pay it, and only paid $10,000. They
So
paid a significant
what
amount.
I'm hearing, and the dispute that I'm hearing between the parties, is that Loyalty believes the performance standards were a part of the contract, and Empirical believes the performance standards were not a part of the contract. And there is a way of looking at the trial court's order, according to Empirical, as saying the performance standards were not a part of the contract. Why is that reading of the trial court's order incorrect?
Because there is no performance. It's not as if, we're going to increase your website traffic by 50%. We're going to
Well,
do
I'm
this.
calling, for simplicity, I'm
Yes.
calling Kentico certification and a functioning website, I'm calling all of that performance standards.
I think the lowest bar of performance under contract is actually getting it's something that you pay for. My client didn't get what they paid for here. At the end of this, they were out $140,000 and didn't have a functioning website. That's straight up breach of contract. That's straight up
So
unjust
do you
enrichment.
dispute that Empirical provided work?
They may have written down that they did some things, but every time they went in to fix something, they broke something else. The analogy that Appellee's counsel used, this is a old car and need a lot of work. Well, you can take your old car to the mechanic, and the mechanic doesn't know what they're doing. They can keep your car for 3 months and work on it, and charge you $100 an hour for it. But if they don't know what they're doing and they're doing it incorrectly, they shouldn't be charging you that. That is not the contract. That is not getting the benefit for what you paid for it. My clients paid a lot of money and received nothing in return. So for that, Your Honor, we would respectfully request that this court reverse the trial court's decision, send it back down to the trial court. These issues can be fleshed out in the trial court, and at that point, if either party wants to appeal it back up to here for a reconsideration of the trial court's appropriate decision, we can do that. Alternatively, this court, if it reviews the trial transcript in this case, should find that there was an implied agreement. My client paid money, did not receive any benefit in return, and is arguably entitled to judgment at that point, and there should be a hearing on damages in the trial court. Alternative to that, the unjust enrichment claim, which the trial court completely disregarded. So, Your Honors, I would respectfully request this court reverse the incorrect decision of the trial court. Thank you.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. We will take a brief recess and reconvene in just a moment. Thank you.
And excuse.
You may.
Thank you. very much.